holding that the statute of limitations started when plaintiff obtained their judgment in Georgia rather than when the judgment was enrolled in Tennessee under the Uniform Enforcement of Foreign Judgments Act. This case goes back to 2012 when a hotel company, Microtel Inn and Suites Franchising, obtained a judgment in Georgia against a handful of defendants. In 2016, that judgment was assigned to Poser, the plaintiff, and in 2018, the plaintiff filed an action in Montgomery County Chancery Court enrolling that Georgia judgment pursuant to the Uniform Act in Tennessee. And in doing so, the plaintiff filed the appropriate documents to domesticate that judgment. The exemplified copy and the defendants were all put on notice, and they had the opportunity to object to the enrollment of that judgment. And they did. The objection was filed, and after a period of activity, the court entered what was referred to as a order on foreign judgment. This was in January of 2022, which stated, importantly, that the Georgia final judgment against defendants filed in this case was properly domesticated as of February 26, 2018, the date of filing, and is recognized in this court as a Tennessee judgment for enforcement purposes. And we think that language is very important for reasons I'll talk about a little bit later. So after the judgment was enrolled, Poser proceeded to file judgment liens in Montgomery County, and then next they filed a motion to sell the real property encumbered by those judgment liens under Rule 69.07. At that point, one of the judgment debtors, Mr. Zaver, I hope I'm pronouncing that correctly, responded in opposition to the motion and for the first time raised the defense that Poser failed to timely renew its judgment, so it should be barred by the statute of limitations. And the trial court, heard arguments from both parties, ultimately took the issue under advisement and issued their final memorandum and order opinion holding that plaintiff's motion to sell and execute on its judgment liens were barred by the 10-year statute of limitations, and held the 10-year statute of limitations started on the date the judgment was entered in Georgia in 2012, not when the judgment was enrolled in Tennessee in February of 2018, according to the trial court's order. So we believe the trial court erred for at least three reasons. First, Tennessee case law, case I'm sure this court's familiar with, Oceanics v. Barber. Now, it didn't decide this particular issue on that appeal, but it was a case about the registration of foreign judgments in the context of piercing the corporate veil and about the statute of limitations. And what the court noted in that case is that if the action brought by the plaintiff in this instant case is to be treated as an action on that judgment, then the plaintiff would have had 10 years from the date of entry of the domesticated judgment to bring such an action. If this had been the context in which the plaintiff's action should be evaluated, the suit, having been filed on April of 1999, was obviously filed in a timely manner. And that language is important because this case is from 2003. This issue has not been dispositively interpreted and ruled on, by a Tennessee court yet. But attorneys and judgment creditors have been looking at Oceanics for 20 years now, and that's what they've been using when deciding when to renew their domesticated foreign judgments. So Poser not only relied on Oceanics, but also the plain language of the trial court's order, which says, which said and recognized the court as a Tennessee judgment for enforcement purposes. And as the Supreme Court noted in the new case, there's a two-step process. First, the enrollment process, which the debtor has various objections they can raise to, during that process. And then once that foreign judgment is enrolled, the Tennessee courts give that judgment full faith and credit, and then it's up to the judgment creditor to execute on it within the state pursuant to Tennessee law. That can be through filing judgment liens or bank levies, so on and so forth. So the second reason is perhaps probably the most interesting, is the substantial weight of authority from the other states who have interpreted this issue under the Uniform Act have held that the enrollment of a foreign judgment in a new state results in essentially a new judgment for the timeline to calculate when the statute of limitations runs. And that new judgment rule is consistent with the trial court's order and reported Tennessee case law.
So you're pointing us to case law in other jurisdictions interpreting the Uniform Enforcement of Judgments Act. But your argument on appeal really doesn't focus on the language of our act. Why not?
Because the Tennessee Act essentially adopts the Uniform Act. It's essentially what it does. So
where would I look to then under our act to say, to support your position that it actually is basically a Tennessee judgment at the point it's domesticated?
Yes, of course, Your Honor. In TCA 26-104, for instance, it states the clerk shall treat the foreign judgment in the same manner as a judgment of a court of record of this state.
So you're saying C part
yes.
control that? Okay.
Yes, yes. And, interestingly enough, while after our principal brief was filed, this court decided a case, Wells Fargo v. Searcy, which is very closely related. I think it gets us halfway there. And Justice Usman offered that opinion. And specifically from that case, he mentioned, quoting from the case, regarding the time frame resulting from the enrollment of a foreign judgment, while there is some inconsistency among state court decisions, it appears a substantial weight of authority holds the filing of a foreign judgment triggers a new limitations period. And that quotes a case from the District of Columbia, the Holt Graphics case, which in that case it string cites about 15 different states who have looked at this. North Carolina being, I think, the Nielsen v. Schmoke case, which is very important because I kind of coined the new judgment rule, which makes it, I think, easy to digest about what courts have done when looking at this. And that Wells Fargo case also mentioned Oceanics. So I think that's important as well for the court to note. And going back to the Nielsen v. Schmoke, that phrase or that case was identical here. It involved a judgment domesticated in a new state under the Uniform Act, and then holding that it becomes a new judgment for purposes of enforcement and subsequent deadlines, like the statute of limitation, restart on the date of domestication. And Nielsen v. Schmoke also relied on the Fourth Circuit of their judicial district, the U.S. Court of Appeals, and the U.S. Code 1963 registration of foreign judgments. And I think all of this is important because this case concerns the Uniform Enforcement of Foreign Judgments Act. Uniformity is very important. And when there is a split between the states, I think there's 15 states who have resolved the issue under the new judgment rule, the rule that Poser argued should apply. There's a minority position that just contravenes the purpose of the Uniform Act. It should be, so Tennessee here, I think they have the opportunity to go down the road of the majority that's consistent with Oceanics, that's consistent with the states that have interpreted this act, or kind of step out with the minority of just a handful of states who have ruled that it should be, the statute of limitations should run from the deadline of the original judgment. I think that also, it raises some practical concerns as well regarding multi-state enrollment, because under the Uniform Act, a judgment creditor can take their judgment and enroll it, as a judgment debtor moves around. They could take it to North Carolina, and in the Wells Fargo v. Searcy case, what happened is there was a judgment from South Carolina, the judgment debtor moved, they took that judgment, domesticated it in North Carolina, then the judgment debtor moved again to Tennessee, they took their judgment from North Carolina that was domesticated from South Carolina and took it to Tennessee. So it presents the minority position, and the trial court's position presents a significant problem, because if you're going to say, well, we should go back to the state where it was originally entered, it contravenes the Uniform Act, and that it allows the multi-state enrollment and enforcement. And the reason being is, that this act was adopted by 48 states, so a judgment creditor did not have to go and file a new lawsuit every time a debtor, moved to a different state. It's supposed to streamline the purpose, streamline the enforcement mechanisms and the enrollment mechanisms, and the minority position makes it more difficult. And during The last reason I like to talk a little bit about is during the Wells Fargo v. Searcy case.
Well, I mean, I guess one counter to that is that a judgment creditor could avoid all this by just going the common law route and actually filing suit for enforcement of the judgment, the foreign judgment here, and getting a new Tennessee judgment in this case. I mean, that sort of resolves the problem of inconsistencies across states, right?
That is correct. They could follow the common law route, Your Honor, but it is much more inefficient for judgment creditors, especially banks, financial institutions that operate.
It's more inefficient, I agree, and it's certainly not as streamlined, but then you have no doubt about your time limits then.
Yeah. There's no disagreement there, but we believe, the purpose of the Uniform Act and the states who have adopted it was for that purpose, for the streamlined purpose, and for uniformity. And Tennessee is one of the 48 states who did adopt it, and we think that's important. And we think that's what judgment creditors and lawyers in the state have been doing since Oceanic, since 2003. So we think if this trial court's order is not reversed, there could be just a lot of chaos and confusion in the Register of Deeds office and other post-judgment enforcement proceedings of foreign judgments about whether or not they were timely renewed under the Uniform Act. I'll be glad to address any other questions you have on rebuttal.
All right, thank you very much.
Thank you.
The appellee. Good morning.
Good morning, Your Honor. My name is William Scales, and I represent the appellee in this matter, Bharat Xavier. As opposing counsel has indicated, this case arises from a judgment collection case, and it focuses on the interpretation application of the Uniform Enforcement of Foreign Judgments Act. As opposing counsel noted, the trial court determined that the Georgia judgment had expired, and because it expired, the statute of limitations barred enforcement action. We submit that you should affirm that conclusion because existing Tennessee law and the policy behind this act support the conclusion that in Tennessee, the statute of limitations for enforcement accrues when the judgment is entered by the rendering state. Now, as opposing counsel noted, there are really kind of two camps, domestication camp and then when the rendering state entered camp. And there's about 15 states in the domestication camp, and there's about 5 states in when the original trial court entered camp.
And so why should we follow the minority view?
I submit that the existing Tennessee case law already put Tennessee in that camp, and I'll tell you why. If you look at the Barone versus Barone case, which we cite in our papers, and the Hart v. Torte case, those support that position. Barone was a case that involved a judgment creditor attempting to domesticate a Canadian judgment in Tennessee. As part of the court's analysis, it explained how, as a general proposition, domestication occurs. It talked about the common law approach, which you discussed earlier. And in Barone, it explicitly notes that the common law approach creates a new Tennessee judgment. In Barone, it also discusses the Uniform Enforcement of Foreign Judgment Act. But with respect to that act, it never calls it a new judgment. It refers to just registration. So I submit that the Barone case demonstrates that Tennessee does not consider a registered judgment to be a new judgment, just merely a continuation. To get a new judgment under Barone, you have to have a petition filed and actually obtain a judgment based on the foreign judgment you suggested.
You have to do the common law route.
Correct, yes, sir. In terms of the Hart case involved enrollment. It's still a judgment creditor trying to enroll a California case in Tennessee. In that case, what's important is the court focuses on when accrual occurs for purposes of the statute of limitations that's at issue in this case, which is 28-3-110. In the Hart case, the court says the statute of limitations accrued when the judgment was renewed in California. So to me, that suggests that this statute, when our courts look at this statute and look for the accrual date, they look at when it accrued in the rendering jurisdiction. So I submit that when you look at those two cases together, the Barone case and the Hart case, they're consistent. It's not a new judgment under the Uniform Enforcement of Foreign Judgment Act, so you have to find out when it accrued in the rendering state. Opposing counsel submits that the Oceanic case goes the opposite direction. I think there's a challenge there. Frankly, I think the Oceanic case supports our position, and for two reasons. One, the Oceanics case involves a Portuguese judgment. In the Barone case, Barone says that the Uniform Enforcement of Foreign Judgment Act should not be used for domestication and enforcement of foreign country judgments. In the Oceanics case, if that were a Portuguese judgment and it were domesticated through the Uniform Enforcement of Foreign Judgment Act, I submit that's probably not appropriate. It was probably domesticated through the common law, which would then make it a new judgment and give you the 10 years that my opposing counsel indicated. The second piece of that is the Wells Fargo case. If Oceanic had been so clear, if Oceanic had said that the Uniform Enforcement Judgment Act, when using that mechanism, creates a new judgment, then the language in Oceanics where it says, so after evaluating and noting that the substantial weight of states favor the domestication approach, this court says, well, we've not actually decided which camp we fall into yet. If Oceanics were so dispositive, were so correct, it seems to me the court would not have said we need not weigh in on this question yet. So again, I submit that this court has already determined, or at least Tennessee case law has demonstrated, that Tennessee falls into the date of rendition camp because of Barone and because of Hart. And to harmonize Oceanic with Barone and with Hart, you have to read that 10 years as being from a new judgment obtained through the common law process, not through the Uniform Enforcement Judgment Act.
But, I mean, you would agree, though, in Hart and Barone and Oceanics even, this issue was never squarely before our court in any of the cases. So really, you know, there's not any controlling authority here.
Fully agree, Your Honor. No controlling authority. I just submit that, I mean, if you look at...
You could read those cases to lead either direction, potentially.
I don't know that you could read them lean the other direction, Your Honor, because at no point...
Well, Oceanics, I mean, you would have to agree, comes the
Yes.
closest.
Yes,
It's
sir.
got that line in there.
Yes, sir. Yes,
But
sir.
then they go on to say, but we're not deciding this issue.
Yes,
Yeah.
sir.
Okay.
Yes, sir. Yes, sir. And then finally, from a policy perspective, Your Honor, or Your Honors, the legislature has instructed that in Section 26-6-102 of the Uniform Enforcement of Foreign Judgments Act, that it should be interpreted to effectuate its general purpose and to make uniform the laws of the state which enact it. Right now, there's not necessarily uniformity. We've heard from opposing counsel there's 48 states that have adopted it. Of those 48, only about 20 have really determined which of the camps they fall into. So choosing one camp or the other right now doesn't indicate that you've done something inconsistent with policy. It would frankly be consistent with policy because there are other states, sister states, who do apply the minority position. So,
Counsel, isn't there commentary to the Uniform Enforcement of Judgments Act? And if I'm correct on that, does it actually say anything with respect to this issue?
in my research, I've not found anything. I'm not saying it doesn't. I've not found anything yet. I've not seen any of these cases quote the commentary that indicates it. It just seems. It seems that some cases, some courts, what they've done is looked at the federal statute and used that as a guide, and then looked at corresponding states.
Yeah, what strikes me as a mistake to look at federal statute, because You just show up in a federal court and file your judgment, and then bang, it's a judgment of the federal court, whatever district you file in. So there's really no analog in the federal system to what we're doing here.
Right, and so it's really kind of left to the states, and right now we have a split because it's been left to the states without much guidance from the drafters. So because I submit that existing Tennessee case law supports the position that Tennessee is in the when the rendering state enters camp, and because the public policy behind this.
Well, and when I interrupted you, counsel, you were getting ready to talk about the policy that backs up your position. So tell me it seems to me that it is much easier from a administration standpoint to say, well, we're just going to count it anew whenever it's registered here. I mean, because you've got everything in front of you. Under your approach, you've got to go back and look at the other state and say, okay, when was it entered in that state? So why, as a matter of policy, does it make more sense to adopt your reading of the statute?
First, in terms of the legislature's intent, they talked about in 26.6102 that let's make it uniform. So I think there's the minority position that says you can use the rendering date. But then secondly, just from a fairness to the judgment debtor perspective, I mean, theoretically, one could obtain a judgment in California and wait until like the final day of the final 10th year, or whatever the deadline is to enroll there, file it in Tennessee and just start anew when it could have already expired. So I think what it does is unnecessarily and unfairly maybe extend the time period in which it can be enforced.
You're saying as a matter of policy, then we should encourage judgment creditors to act quickly
Correct.
to execute on their judgment. Okay.
And once a judgment is obtained, the judgment creditor has the ability to conduct whatever searches are required to identify where property may be located. And each state, it's incumbent upon that judgment creditor then maybe engage counsel in each of those states to find out, what is your deadline, how much time is required, and through that process, as you've indicated, it's incumbent upon the judgment creditor to identify how to best collect on their judgment. That's not something that should penalize the debtor. It's up to your questions, Your Honor. Those are my points.
Hearing no further questions, thank you, Mr. Scales. We'll now hear rebuttal.
Regarding just quickly on Barone v. Barone and Hart v. Torrey, both of those can be distinguished because Barone involved a Canadian judgment. It's not a signatory of the Uniform Act, and Hart v. Torrey is about enrollment in California law, which is also not a signatory of the Uniform Act. And I think it's important to just point out the statutes applicable here, 28.3, 110, when the cause of action accrues.
Is that a prerequisite to enforcing a foreign judgment, that the judgment was rendered in a state that has adopted the act?
No, it's not, but it is important.
So why would we care that it's Canada or California?
I think it's important when examining upon enrollment, because really there's two issues. I think it's very appropriate to look back at the rendering state on the enrollment phase, and that's what Justice Usman mentioned in the Wells Fargo v. Searcy opinion. Look back at the rendering state, but after it's enrolled, which the judgment was undisputably enrolled here, after enforcement, it's an entirely new act. It's a new analysis. And, opposing counsel mentioned some of the policy considerations, and Justice Usman also mentioned some of that in a footnote of the Wells Fargo opinion, that when a party is seeking to limit the full faith and credit that Tennessee gives to judgments from sister states, it's a stern and heavy burden. And that's from the Supreme Court case, I believe. And generally the examples given were...
Well, but here it's not that we're not giving full faith and credit. We're just saying you waited too long.
And we don't disagree there, Your Honor, but what I would say is, again, going back to sort of the core issue here of the statute limitations, the cause of action accruing. How can a cause of action accrue in Georgia in 2012 when the case did not even exist in Tennessee until it was domesticated and enrolled? because otherwise Tennessee had no relation. It may not have, and it never would have unless the judgment debtor moved here. And so we think that language is important. And the court also, the trial judge mentioned 25-5101, which concerns the real property and judgment liens, and used the term rendering as well as to real property. But again, how can the 10-year clock start in 2012 before a judgment is enrolled and even recorded on any real property within the state of Tennessee? It's another reason why it would be more appropriate to wait until domestication.
But it would be conceivable that the Georgia judgment could have expired. It's a 7-year statute of limitations in Georgia. If you waited 7 years plus a day to file your judgment here on the Uniform Enforcement of Judgment Act, it would be too late. I mean, they would have a valid defense, would they not?
That's correct. And our position is that's an issue for enrollment, not enforcement. All right. Thank you.
All right, thank you both for your arguments. We'll take your case under advisement. That concludes the morning docket.